back to Winning Isn't Easy. Why an ERISA disability carrier doctor's opinion can make or break your ERISA disability claim. Now, when you apply for your ERISA disability benefits, your application is reviewed by a claims examiner who's probably going to order all your medical records and request that your physician complete an attending physician statement form that addresses your diagnosis, your treatment, and your restrictions and limitations. Once the records and the APS forms are obtained, the claims examiners are going to have your medical records reviewed by a nurse case manager or a physician employed by the disability carrier plan. That's to assist the claims examiner in making the initial determination of whether or not you're disabled under the terms of your policy or plan. Now, if your medical records are unavailable or insufficient for the carrier or plan to decide, the claims examiner is going to consult with their own physicians or consult with a peer review provider that they may hire. Often the initial review is done by a nurse and then reviewed by a medical director, all of whom are employed by the disability carrier plan. And generally, they are not specialists in whatever your medical condition might be. These doctors are going to be asked to render an opinion about the medical or psychological issues in your claim. So what are they going to address? The diagnosis, the severity of your impairment, the nature of your symptoms, the severity of your symptoms, the nature of the treatment that you were prescribed, your response to that treatment, your functional capacity and capabilities, notwithstanding your disability, the potential length of your disability, the consistency of your complaints and the nature of your disability, whether or not your disability is due to subjective medical conditions, and whether your disability is due to mental nervous conditions. So that's all fine and good, but you need to remember that there is no treating physician rule in ERISA. What that means is that the carrier or plan is not required to give your physician's opinion any deference or any special weight. In fact, as a practical matter, the disability carrier plan are going to defer to their nurse, their medical director, or their peer review doctor's opinions that allow them to deny or terminate benefits. Now, the paper review doctors don't have an opportunity to examine you. So what do? They have a lot of tools that they will use or techniques that they will use. They're going to pick apart the diagnostic studies found in your records, such as the MRI or CT scan. They're going to look at your medical records. They're going to say that the exam findings are not consistent. They may say that the MRI or CT scan findings are not consistent with the exam findings, or they're not consistent with the restrictions and limitations assigned by your physician. They'll say that the level of treatment that you have been getting is not consistent with the level of your complaints or the nature of your pain complaints. Now, there are other things that they do wrong. They're supposed to provide a written analysis of the medical records, and the claims examiner is required to explain ultimately how they arrived at the decision to deny or terminate your benefits. This isn't always the case. There can be this disconnect between the questions that are asked, the questions that aren't asked, and the conclusions that the peer review doctor or nurse reach about your diagnosis, your restrictions, your response to treatment. You'll see gaps as if they've cherry-picked your medical records, or they purposely aren't asking the right questions. Now, what we always want to do when we get the claims file is to take apart the carrier or the plan's rationale for the claim denial or termination. We want to look at the medical records and see whether or not that claim denial rationale or termination rationale is consistent with what is or is not in the medical records. We also obviously want to look at the nature of the medical provider's opinions. Are they a specialist? Do they understand the nature of this condition? Did they have all the medical records? Did they jump to conclusions or have leaps of logic in their attempt to create a reason to justify a claim denial or termination? Now, these are just some of the reasons that medical opinions can make or break your ERISA disability claim. And I think you can understand why you might need an experienced ERISA disability attorney to help you with a disability appeal of a denied or terminated claim. Got it? Let's take a break.